2020 is hereby called to order. Statements by ministers. Announcements.
Laid on the table of the Senate today is a copy of the report of the compliance audit of the Constituency Development Fund.
Thank you. Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 7th day of November 2020, the following bills were passed in the House of Representatives. A bill entitled An Act to Amend the Bank of Jamaica Act, a bill entitled An Act, and a bill entitled An Act to Amend the Shipping Act.
Mr. President, I signify my willingness to take charge of the bills.
A bill entitled An Act to Amend the Bank of Jamaica Act for the first time. A bill entitled An Act to repeal the Dogs Liability for Injuries by Act and to provide for liability for attacks by dogs and for connected matters for the first time. And a bill entitled An Act to Amend the Shipping Act for the first time.
Mr. President, I beg to give notice of second reading of the bills.
Thank you, Minister. Petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the Senate, motions for leave to introduce bills, the presentation of bills without the leave of the Senate first obtained, public business. Minister.
Mr. President, are you able to hear from me? Mr. President, the matter before the Senate at this time is the Act to Amend the Revenue Administration Act 2020, which was passed in the House of Representatives, passed in that other place, on November 10th, 2020, and drafted pursuant to a Cabinet decision of December 2017. This bill, Mr. President, seeks to incorporate into domestic law the Common Reporting Standard, which I'll refer to as the CRS, of Automatic Exchange of Information, AEOI, as well as the text of the Convention on the Mutual Administrative Assistance in Tax Matters, which I'll refer to as the MAAC in this presentation. Mr. President, these amendments are intended to increase transparency, ensuring that Jamaica is a safe place to do business in keeping with the global standard. This is, of course, consistent with Vision 2030 for Jamaica and will certainly aid our efforts to achieve the United Nations Sustainable Development Goals. By way of background, Mr. President, exchange of information between revenue authorities has been a long-standing part of the legal and domestic landscape in Jamaica, forming the basis of an article in our double taxation agreements, as well as being the subject of standalone bilateral tax information exchange agreements. However, in the aftermath of the global financial crisis, the political momentum with respect to international tax matters, it shifted towards opportunities provided by automatic exchange of information. And as such, in September 2013, the G20 finance ministers and central bank governors determined that automatic exchange of information was a new globally expected standard. Members will also recall that the Foreign Account Tax Compliance Act, known as FATCA, was approved in 2013 and it was introduced in 2015 in Jamaica, providing for the reciprocal automatic exchange of banking information between Jamaica and the United States. This was and is a bilateral arrangement. But by 2014, more than 104 jurisdictions had committed to swiftly implement a multilateral automatic exchange of information through the MAAC using the Common Reporting Standard Platform, the CRS. The MAAC is a multilateral convention that was designed as an instrument of international law to facilitate all forms of administrative cooperation. It contains strict rules of confidentiality and proper use of information and permits, as indicated, automatic exchange of information. One of its main advantages lies in its global reach with 141 signatories as at September 1, 2020. Mr. President, Jamaica signed the MAAC in 2016. We ratified it in 2018 and it entered into force on March 3rd, 2019. Few years, 2 or 3 years, many other Caribbean countries, including Barbados and Trinidad, updated their domestic legislation and operationalized automatic exchange of information under the MAAC using the CRS platform. And we appreciate that while these and other countries may have faced external pressures to do so, Jamaica was not seen and has not been seen as a harmful jurisdiction by the international tax community, and has in fact been a role model and example in the region in respect of tax compliance, in respect of its compliance or our compliance with the global standard. In that context, we weren't previously required to commit to starting automatic exchange of information, but as we seek to maintain high standards in tax compliance and our global standing in this regard, we are now proceeding to this next level of legislative strength. Regarding the CRS, Mr. President, the information which forms the focus of the global model for automatic exchange is financial and banking information. So the CRS, with a view to maximizing efficiency and reducing the cost for financial institutions, draws extensively on an intergovernmental approach, which is already used by through implementation of the FATCA. And while there are some deviations in this regard from the FATCA model due to the multilateral nature of the CRS, and of course some other deviations because of the US-specific nature of the FATCA, apart from that, there is very little fundamental difference in the substance of the requirement under the MAAC. In fact, the differences are largely based on terminology and the difference between dealing with one country versus a multiplicity. So the CRS in this regard will operate in substance as FATCA on a multilateral basis. The effectiveness of any model of automatic exchange of financial account information depends on its standardization in order to benefit the maximum number of jurisdictions, while recognizing simultaneously that certain issues remain to be decided by local implementation. The advantages of standardization include process simplification, higher effectiveness, and lower cost for all stakeholders. And the main success factors for the effective automatic exchange of financial information are: 1, a common standard on information reporting, due diligence, and exchange; 2, a legal and operational basis for the exchange of information; and 3, common or compatible technical solutions. So, Mr. President, in this regard, Jamaica intends to leverage its successful experience in the implementation of FATCA to proceed with the introduction of the CRS locally. To this end, there have been stakeholder consultations with a number of representatives of various private sector organizations, including the PSOJ, the Jamaica Chamber of Commerce, the Bankers Association, and numerous financial institutions. The representatives were sensitized to the CRS and had the benefit of expertise of the OECD to address their concerns. Regarding implementation, This requires translating the CRS into domestic law, and it was understood that this could be done either by copying the text of the CRS into domestic legislation or by amending domestic legislation to make reference to the CRS as an external document. So, Mr. President, in keeping with the manner in which the FATCA was incorporated into domestic legislation, it was determined that the reference method would be more effective to maintain the continuum of our current legislation. It was thought that the seamless incorporation would also be more conducive to making the transition easier for all relevant stakeholders. So in this regard, Mr. President, there are proposed amendments placed before us today. Sections 17NB, 17NC, 17ND, and 19, and the first and second schedules have been amended, Mr. President. The bill seeks, firstly, to propose new insertions of 17ND as well as a third and fourth schedule. They, in sum, Mr. President, are designed to augment the minister's power to make regulations in respect of international agreements and modify existing regulations in keeping with international developments and Jamaican policy. So in particular, 17NB, Mr. President, the amendment to 17NB empowers the minister to make changes to the second and third schedules, which will contain the regulations, as I will speak to in a few more seconds. And it will also allow for speedy updating of any changes that may be made to the text of the convention on the MAAC, to which Jamaica may accede. Mr. President, in respect of 17NC, this is under clause 3, the provision is amended to make reference to the first schedule as opposed to simply the schedule, recognizing that, of course, we are adding new schedules to the Act. Mr. President, clause 4 of the bill before us allows for the regulations contained in what will be the second and third schedules to the Act to be construed as having been made by the ministerial powers under 17NB, to which I have just referred. And clause 5, which speaks to the amendment of section 19 of the Principal Act, it deletes subsection 3 of 19, making sure to delete some duplications which would have caused some confusion with the insertion of new clause 17ND. So, Mr. President, clause 6 amends the first schedule, and it adds the MAAC to the list of agreements, Mr. President, to the list of agreements entered into between Jamaica and other countries for the exchange of financial and other information for tax purposes. And the MAAC is the second such listed agreement, with FATCA having been the first. And clause 7 is an amendment consequent on the deletion of 19.3, which I just referred to under clause 5, and the insertion of the new 17ND. Clause 8, Mr. President, inserts the new third and fourth schedules. And Mr. President, the third schedule contains the substance of the CRS. It includes, or rather inserts, the substance of the CRS as regulations. And Mr. President, in so doing, we note that any jurisdiction which is implementing the CRS must have rules in place that oblige the financial institutions to follow due diligence processes, procedures consistent with the procedures in the CRS, and to report relevant information consistent with the reporting terms outlined in the CRS. So to facilitate consistent application of these terms, an interpretation section is also included in the regulations to clarify its scope and intention. And as you will see, the financial institutions covered by the CRS include custodial institutions, depository, investment entities, and specified insurance companies, unless they present a low risk of being used for evading tax and are excluded from reporting. The financial information to be reported, Mr. President, with respect to reportable accounts include interest, dividends, account balance or value, income from certain specified products and other specified accounts. And all of these terms are defined as appropriate in the regulations now set out in the third schedule, Mr. President. As with the FATCA, the regulations also speak to the rules, administrative procedures, and compliance mechanisms of the CRS. And the regulations include lists of the participating and reportable jurisdictions of the CRS. These are set out in parts 1 and 2 of the schedule to the regulations. So this is the schedule to the regulations which now form the third schedule to the Act. So, Mr. President, listed there are the participating countries which will share information with Jamaica automatically, and the reportable countries, jurisdictions, participating and reporting jurisdictions, with whom Jamaica will share information automatically. They are identical lists, as a commitment is reciprocal among all parties to the convention, and this is the body of jurisdictions with which Jamaica now has this agreement on passing of this act. In the event that there are changes, Mr. President, these may be made by ministerial order. And this is a reflection of the multilateral scope of the CRS, as it reflects the parties who will automatically share and for whose residents Jamaica will be obliged to exchange information automatically. The newly inserted fourth schedule, Mr. President, contains the entire text of the MAAC. And again, for clarity, the convention serves as the modern approach to administrative assistance in compliance, as countries are now able to engage on a multilateral basis with an instrument that is wider than a traditional double taxation agreement, both in scope, in terms of tax types covered, and the modes of assistance that are available. So as stated earlier, Mr. President, in closing, these amendments are intended to effect the government's policy to increase transparency and ensure that Jamaica is a safe place to do business in keeping with the global standard, consistent with Vision 2030 and the SDGs. Mr. President, although the move to the AEOI standard is still relatively recent, it was noted that it's already having a significant impact. And the OECD Secretary General reported to G20 leaders in Osaka June last year, under the Japanese presidency of the G20, that in 2018, information related to 47 million financial accounts was exchanged with a combined value of 4.9 trillion euro. The AEOI standard further contributed to the international community, recouping over 100 billion euros in additional revenue, tax interest penalties through voluntary compliance mechanisms and other efforts. Mr. President, as Jamaica works towards continued growth and development, these amendments are designed to ensure increased compliance by entities operating within the country, as well as to maintain tax transparency. And this will in turn maintain and even enhance Jamaica's reputation in the global landscape. It is in this context, Mr. President, that I commend this bill for the Senate's consideration and approval. I thank you.
Thank you very much, Minister. Senator Brown.
Mr. President, the opposition recognize that this bill is a continuation of work started many years ago. As the Minister said, the global crisis of 2008 onward is part of the catalyst for legislation like this and for the approach being adopted globally. The desire for transparency and desire to hold businesses to account for paying their fair taxes to respective nations is also part of the reason for this legislation. There's no disagreement between the government and us in respect to this. It reaffirms, as the Minister said, the importance of the multilateral approach to agreements. And maybe it's an opportunity to say, hopefully November 3rd has begun a renewed respect for multilateral approach in the world rather than any single nation first. The world is learning, Mr. President, how difficult it is and how one single individual can seek to thwart the democratic will of the peoples of the world, and more so the people of their own country. You, Mr. President, would know that one of the biggest defenders of democracy has been the United States of America. Recently in CARICOM, we had a difficulty in elections in Guyana. And everybody said, oh, the U.S. will help out and ensure democracy prevails. Now the world is looking on and saying, where is the democracy in the United States? Where is the will of the voters? And it's important that we recognize this as we get into multilateral arrangements like this mutual administrative assistance and tax matters treaty. That we have to insist that all the parties play by the same rules. Minister, you're right. Jamaica has been a role model. But we have to call others to be role models too. We have to call on others to respect the rule of law, respect the democratic process, and to recognize that this will exist no matter who is the leader of any particular country in the convention. And so the lessons we're learning here, and I want to commend the approach being adopted by the transition team of President-elect Joe Biden and Vice President-elect with Jamaican roots, Kamala Harris. I want to appreciate the fact that they have indicated their respect and support for multilateral approaches by announcing the rejoining of the Paris Climate Accord. And I think we should hail them for doing that. In the midst of the COVID-19, President-elect Biden has indicated that they will rejoin the WHO. Important for us. Because as Eric Williams once said, 1 from 10 leaves 0. And if we got into a world where 1 from 104 or 1 from 198, we could end up with these conventions being not worth the paper they're written on. So the opposition supports. We support it because we believe the multilateral approach is good. And we also believe, Senator Webby, that some business people exploit the global tax system not to meet their obligations to the people who make it possible for them to succeed. Mr. President, this bill some may say, it really doesn't affect the ordinary people in Jamaica. It doesn't affect the working class, Senator Gale. Though connections can be made to show its impact. When on page 9 we see the type of people they're looking at, President, in the definition, high-value account mean a pre-existing individual account with an aggregate balance or value that exceed US $1 million. I know that's not Ronnie. It may be me. Yeah, I don't have no problem with that. But that's me who is not working class. But the me who is working class will have difficulty even getting to Jamaican dollars. So it could be said, President, that our time today is to look out for those who have a lot of money. And this is why I want to urge the government, as part of its tax administration policy, Minister, to look at some things that affect the working people, especially at these hard times in the country. A country impacted by COVID. We see the devastation in tourism. We see the problems around the country where people are losing their jobs, where poverty is increasing. There are some areas of tax administration, revenue administration, that I'd like to commend the government attention. And I start, Minister, with two specific areas of taxation in relation to uniform and laundry. And I know I can plead the support of my colleague, Senator Gale, in saying that judges, nurses, police, factory workers, workers in hospitality, who must now don more clothes, more uniform because of the COVID issue. That it can't be that the government and successive government, let me make it clear, successive governments, but this is the government in play today. This is the government looking at tax administration. It cannot be that from the 1990s, the tax relief for uniform was $5,739. And that on laundry, $3,395. So that's all, if you're going to be provided with money for uniform, be you a judge, because judges is on that list. Be it the work at Grace Canning, SAV meat packaging. The reality is this type of threshold above which everything else is taxed can't be right. And I appeal to the government. Senator Hill, I appeal to you, the man who wants to remove taxes from everything and the people. I appeal to you as a cabinet minister to have the government review, and this is something I talked about with the support of Senator Gale when we were on the other side. So it's not new, but it is too long. Now we need to change. We need to change that threshold and allow greater relief for those who must now wear the uniforms. And more so in this COVID time. So I'm appealing and I'm urging the government to look at the uniform and the laundry tax levels and ease the burden by increasing the amount of tax-free part of those benefits. As we deal with the high-value companies, the high-value accounts, we need to deal with the little man in the shop floor, the man who is producing the goods and service, which will allow the profit to be made for the high account, high-value account people. Another area of tax reform that I want to urge the government to do is the income tax order of 1971, Senator Bryan, relating to severance pay and issues like that. This order, Mr. President, was prior to the Industrial Dispute Tribunal being set up, prior to the Employment Redundancy and Termination Payment Act coming into being. It was a good legislation when it came because it eased some of the burden on the taxpayers. But that's 71. That's what, 29, that's almost 50 years now. But that is still the defining legislation. And Senator Ransford, I believe this annual salary at that time that it applied was $7,000. No, not weekly, no. The annual salary at that time in 71 that trigger anything was $7,000. Any indexation from 71 to now probably would take that to 7 million. The reality is that I'm calling on the government to review this income tax order of 71, to see and to meet, just as you met with the stakeholders, private sector, Chamber of Commerce, to bring in the trade union, Senator Gill, in a consultation to see how we can improve the 71 order. And let me tell you why it's so important, Mr. President. In recent times, because of the good work of people like Senator Brown, am I giving you credit today? The Industrial Dispute Tribunal makes awards. But those awards are not treated like court judgments. So they may make an award on unfair dismissal. And in so doing, the taxation applied to those awards is heavy. So you win a case, Senator Gill, for unfair dismissal. But the real beneficiary is the tax department. And I believe the 71 order, the 1971 order, need to be tweaked, need to be examined, and make adjustment to treat, is my suggestion, the awards of the Industrial Dispute Tribunal akin to judgments of the courts. For example, a worker gets an award, pays Ronnie, pays some lawyer to represent them, but this is after the tax department has gone in. So that worker cannot claim the expenses. Cannot claim the expenses. And that ought to be changed. So the Uniform and Laundry, the Income Tax Order of 1971 in respect to termination of employment benefits are issues which I urge the government as part of the broader tax administration, not just looking at the high value accounts of $1 million plus and others, but to address the small man, the little man, who is so important. Senator Webby, the worker in the supermarket has to be properly hygiened, has to change uniform. And if you have to provide that uniform, it can't be that it is tax. If you give the person the money to buy the uniform, it is tax at 25%. But the only tax relief is $5,000. Can't be. I don't think at $5,000 can buy, let me see now, Senator Samuda's, no, not Samuda. Senator Hill's necktie. It can't. So let's get realistic. This is a figure that has survived successive governments. It has survived successive governments. It is time to fix it, and you'll have our support. And the last issue of taxation administration that I want to raise before I sit, Mr. President, has to do with the education tax. The education tax was introduced in the 80s. It was ostensibly to provide money to assist in the education of our people. Sadly, that money went into the consolidated fund. And from the consolidated fund, you have money for CDF, and I'm just seeing the audit report. But let me not trouble the CDF. Suffice it to say that the education tax is really an income tax. And while you say we have abolished income tax below 1.5, the reality is that the worker has to pay education tax from the first dollar. Granted, not at 25%, but at around 2%. It's time to lift that education tax. That income tax really is what it is, from the bulk of the workers, certainly those below 1.5. You can't say you're free of tax at 1.5, but your income, your education taxing them. It's not right. And so while we have no problem with the global, joining the global approach to some of these issues of taxation, charity begins at home. Learn to dance a yard first. And on behalf of the people, the working people of the country, I make that plea to the government. Reform the uniform and laundry. Reform the income tax order of 71 and change, relieve workers below 1.5 of the education tax. Mr. President, it's a 50-odd page bill, but we should leave here early today. May it please you.
The source of your optimism eludes me at this time. Thank you, Senator Brown. Senator Webby.
Sir, thank you. Thank you very much. Thank you very much, Mr. President. I think if I was listening, and I was listening very carefully to Senator Lambert Brown, I think the change of environment has done him very well. Because Senator Hill, my understanding, and I don't know very much about tax, but it sounds to me like he was agreeing with the threshold of the 1.5. Yes, thank you very much. It is unfortunate that it took him 4 years to agree to it, but nevertheless, it's never too late. Well done, Lammy. Well done, Lammy. Mr. President, I rise in support of the Revenue Administration Amendment Act 2020 without hesitation. Mr. President, the automatic exchange of information which the Convention imposes has been recognized to be a positive step for global transparency and is a global standard which has gained momentum in the last few years following several high-profile tax evasion cases. Mr. President, according to the Organization for Economic Cooperation and Development, automatic exchange of tax information involves the routine and periodic transmission of information about non-resident persons sent by the jurisdiction in which income or assets are located to the jurisdiction in which a person may owe tax. The exchange of information is automatic in that it occurs on a regular basis. The information may also be held by tax administration or be provided by third parties such as financial institutions. The truth is, Mr. President, as you heard from the leader of the House, Jamaica, we have had experience in implementing bilateral agreements for sharing information with other jurisdictions. The latest and most high-profile one was FATCA with the USA, and I understand that is working extremely well. The truth is, with globalization and with the latest in technology, Senator Morris, where somebody can press a computer button and wire millions of dollars in seconds to another account, we must take this into consideration about the changing world. And what that is saying is that individuals and corporations, companies, they hold assets and investments and do business in multiple countries, and that is now a basic standard in terms of how business is done. In my research, colleagues and President, reading the OECD report, I would like to highlight to this Honourable House what I have categorized as 4 benefits of this legislation for Jamaica. The first one, Senator Hill, it maintains the integrity of our national tax system. 1. 2, and I think Senator Brown, that's where he was heading, it contributes to creating equity and non-discrimination in taxation by ensuring each person fulfills their tax obligation. And 3, it prevents tax fraud. And 4, it improves the collection and recovery of tax revenues. So if we look at those 4 benefits, Mr. President and colleagues, I think it is clear that this bill is absolutely moving in the right direction when you speak about maintaining the integrity of our national tax system. Mr. President, it goes further than that for me, and for the business sector, and for Jamaica. I am really in support of the bill because I believe it can also build Jamaica's credibility in the international community regarding its money laundering and counterterrorism financing obligation. This bill, Mr. President, shows that Jamaica, it shows that we are serious about creating systems and rules which function in line with international best practices. There may be also some benefit with the investigation and prosecution of crimes involving money laundering and tax evasion, which are interconnected. I consider that to be a huge, huge plus. Mr. President, the automatic exchange of information involves the transfer of personal information about investors, such as bank accounts, revenues, and financial assets across borders. The need for global transparency must be balanced with data protection safeguard to protect the taxpayers' rights to privacy and confidentiality. Laws such as the GDPR and our Data Protection Act must be enforced to protect against data breaches in the exchange process and to ensure taxpayers' data is used only for the intended purposes. I also noted that this legislation, very important, imposes obligation of confidentiality on persons who administer and enforce regulations made thereunder, and is commensurate with penalty for breaches of those obligations. I welcome the inclusion of this provision. I read in my preparation, colleagues and President, a report from the European Commission to the European Parliament and the Council. And they highlighted a number of areas which I think is relevant to Jamaica. The first point that stood out for me, was that a country's internal tax recovery system must deploy sufficient resources to deal with recovery assistance requests. And that is an area, Senator Hill, that we need to ensure, which I know is being done, that the TAJ, Tax Authority of Jamaica, have enough resources to ensure that we can fully support this new legislation. And the resources will come in terms of legal and technical and otherwise. The other important point from that report, it also recommended an increase, Madam Leader, in communication to explain and promote this legislation in member states who contribute to increased tax compliance and respect of taxpayers' rights. And I think that's an important part of moving forward in terms of the increased communication. And finally, Senator Brown and Motley, the use of technology. Because when you start to get a lot of volume, we need to have the requisite technology to support it so we can be very efficient and be very supportive in terms of how we administer our obligation. So, Mr. President, without hesitation, I wholeheartedly support this bill, and I think it's going to help Jamaica a far way in terms of our reputation and showing our seriousness in the international market. Mr. President, I thank you.
Thank you very much, Senator Webby.
Mr. President,
Oh. Senator Binns.
thank you, Mr. President.
Senator
And-
Crawford. Senator Crawford. Thank you, Senator Fraser Binns.
Thank you, Mr. President, and I assure you that I shan't be very long. But I want to make some brief comments on this bill, an amendment to the Revenue Administration Act to give effect to what is called the MAC. And like my colleagues before, Mr. President, I join in the support of this bill. We believe that it is a bill whose time has come, and we do not have any issues with giving our support accordingly. But, Mr. President, as I went through the bill and the treaty, there are some questions which came into my mind, and for which I will ask the Minister for her response. But before that, I think it was Senator Webby who spoke about the importance of this bill within the context of the digital economy. The truth is that there is no longer a divide between what we call the black and white real economy and the digital economy, because, and particularly with the advent of COVID, when there's a plethora of businesses online, anything you want, you can get, whether it is fast food, you can get it online, clothes, jewelry, anything at all, you can get it online. And so the digital economy has really ballooned exponentially in the last 6 or 7 months of this year, consequent upon COVID. And so it becomes even more important that a bill of this becomes in place. But I wondered, Minister, because when the Minister of Finance spoke in the other place, he mentioned about the investment opportunities available, which I agree. But I wondered whether there was anything in place to ensure that Jamaican businesses are indeed protected and that profits are in fact coming into Jamaica so that the country can benefit. So I wanted to know whether there has been any work in that regard. And that is particularly important because of the issue of profit sharing and who is going to benefit. Minister, the other thing to which I addressed my mind was that of FATCA, and I know that Senator Webley spoke about it, and we all know about FATCA and the work it has been doing. But if you could, in your closing, just help us to appreciate where we are now with FATCA, how FATCA has been working, and how will this advance FATCA? Though there are two different things, there are still some similarities, and how will this advance FATCA? speaking about FATCA as well, the good thing about this is that FATCA is a bilateral agreement between states, and we have a whole of those in so many different states. And the good thing about this act is that what it is doing is it's multilateral. So it reduces all the need for those bilateral agreements, and it allows for predictability and for there to be continuity among countries. And so it is a good thing. But I particularly am interested in finding out how FATCA has been working. And as we talk about FATCA, it's the sharing of information. Have we been able, I know because of where I worked in the past and because of things I have to do, that we have to share in Jamaica, we have to share information with our partners. But I wondered whether Jamaica has been having the same kind of response from the larger countries, like the United States, like Cuba, like United States, like UK, in terms of us receiving information. And so if you could help us, Minister, that would be useful. And who is the person or persons or the desk, whether it's in your ministry or the Ministry of Finance, that is charged with responsibility for this area, whether it's going to be under FATCA or under the MAC. So I'd be grateful for that. And the major part of this bill is about information sharing. And we are aware that very recently, prior to the prorogation of Parliament, we passed the Data Protection Act. And I wondered what, if any, effect this is going to have on the Data Protection Act, or the Data Protection Act will have on this, and whether we have put things in place to ensure that there is not a divide, but a continuity and a support of the provisions in the Data Protection Act in terms of the sharing of information. The other issue I have, Minister, has to do with the Data Protection Act, and it's not an issue per se, but I was trying to find out whether the act has been brought into effect, and I could not find that out. So if you could, in your closing, just remind us whether or not it has been brought into effect since it was passed. That would be useful for me. The final question I have, Minister, and I know it's a part of the existing act, but and the spokesperson on finance brought it up in the lower house, and this is a 50-page document, and we all know that the RAA is already a bulky document, and I wondered whether there was any way in which we could have created an act, a standalone act, instead of adding this to what is already a very, large bill act. And it's important because, notwithstanding the fact, in fact, it is because it is a technical bill, why it is so important that we make them accessible and easy to read and understand by all persons. And I don't know whether we have, and this is something that as we go about, amending laws, as we go about implementing international conventions, that we consider whether it is easier for the purpose to have a standalone legislation or to just have a composite with something that is already a large piece of legislation, such as the Revenue Administration Act. But with those comments, I really want to say that we support the bill, but I would be very grateful, Minister, if you could shed some light on the questions that we have raised. If it pleases you, Mr. President. Thank you.
Thank you very much, Senator Fraser-Binns. Leader?
Thank you, Mr. President. While I wait for the technical team from the ministry to provide me with some more detailed information about the FATCA, and I must say this, my writing cannot bear any boasting at all. All right. I think revenue. Sorry. All right. You know what I'm going to do? Let me start with the ones that I let me start at the end and go to the beginning. I just need a little clarity here. Thank you very much. Regarding the structure of the Act, I actually started with that in my presentation, that the determination was to ensure for clarity, cohesion, and for continuity from a structure perspective, to use the same methodology that was used for the FATCA, which is to incorporate by reference and incorporate the whole document, adjusting only for the slight differences in terminology for consistency with the language. That was the best way to ensure accuracy and to ensure that the benefits of the bill can actually be attained, which is, as we have all spoken about, one of which is grounded in its standardization. So every country who is signatory, every participating and reportable jurisdiction must be able to rely on the standardization of what we're agreeing to what we have agreed. And that's why the structure is as it is. Yes, admittedly unwieldy from a research perspective, but it does keep the provisions of the convention and the regulations whole for the purposes of ensuring that they are applied effectively and accurately. You asked if the Data Protection Act has been brought into effect. You might recall that that at that time, at presentation, we spoke of a 2-year transition period for that act, so that the office itself could be set up, the administrative side of recruitment, etc., that all of that could be in place, so that when the act comes into full effect, so that the only elements which are in place are those which are required for the inclusion, or rather for the establishment of the office, and the preparation, technical preparation that's needed from the technological perspective. And in terms of the compatibility of the DPA, that is the approach that is always taken to any legislation and to entry into an international agreement, is to ensure that CPC, the Attorney General's chambers, Solicitor General, and the relevant ministries ensure that there is compatibility with Jamaica's existing legal framework. I also said in one of my earliest paragraphs this morning that there are strong protective provisions in respect of, and this may well be why, because I'm not sure if you're not hearing me, because, and maybe you were speaking when I was speaking earlier, which is why you didn't hear when I said that there are strong provisions for confidentiality of information and the administrative regime that is used for exchange. There is a strong regime around it, and therefore it will not be incompatible with what we have here. The anticipation is also that what has been put in place for implementation of FATCA, which has the benefit of time, has the benefit of regularization, and having been used for some years, that is being built upon, and therefore it will be, it's thought that it will be a more seamless implementation even than existed with FATCA. So there is some comfort to be had from that. Right, and regarding how FATCA is working, we're advised, or I'm advised, that there have been 5 successful exchanges requested under it. It's been facilitated with the TAJ, and it has allowed, importantly, the TAJ to collect revenue from Jamaican taxpayers in the U.S. Yes. So it is working for the benefit of Jamaica as well as other countries, and therefore is absolutely something to be lauded. In respect of the implementation and who manages these requests, there is actually an exchange of information unit at the large taxpayer office of the TAJ. And that unit has been trained and continues to be trained in data protection, confidentiality, and other EOI-specific issues. So again, we can give assurance that these matters are being treated with appropriately and will continue so to be. So I hope this answers the question and also places us in a position, Mr. President, where we recognize bipartisan support of this bill, recognition of its importance to Jamaica and its potential importance in terms of strengthening and increasing our global standing on these matters, and certainly enhancing international cooperation in this regard. So with that, Mr. President, I ask for second reading of the bill.
Thank you, Minister. The question is that the bill be read for a second time. Those in favor? Against?
A bill entitled An Act to Amend the Revenue Administration Act, read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. I think with the agreement of the membership, I can take a number of the clauses together, although I was reminded that one of the sessions that I attended recently, that it ought not to be done in that way. Thank you very much, Ms. Curtis. But I'll proceed. I put clause 1. Those in favor? Against? Ayes have it. I put clause 2, 3, and 4. Those in favor? Against? Ayes have it. I put clauses 5 and 6. Those in favor? Against? Ayes have it. I put clause 7 and 8. Those in favor? Against? Ayes have it. I put the title and enacting clause.
President. Chairman, in respect to clause 8, it contains...
Let me put clause 7. Those in favor?
Aye.
Against? Clause 8. Senator Brown.
I think some of my colleagues may have some questions arising from the third schedule, and certainly would appreciate them being heard.
Okay. I have a question relating to 13 and 14.
Which page?
Page 32 actually. It makes reference to the penalties applied, or penalties in section 2, which is the person who discloses or divulges any information or produces any document relating to, etc., $1 million. 14.1.2, also $1 million, and $500,000 respectively. However, in section 4, I found it a little inconsistent, and I don't know if it's an error, that the person, and I'm assuming here is the person who is the holder of the account, if that person is found to have made a false statement or any omission in respect of any information required, that fine is not exceeding $10,000. And also in section 5, $10,000. So there seems to be a bit of inconsistency in terms of the level of fines applied, where the institution can be charged up to $1 million, but the person who is the holder of the account, who is the holder of over a US $1 million account, if there's any error or omission on their part, that they're charged $10,000, and I'm assuming here this is 10,000 Jamaican dollars. So I was just wondering about the consistency or inconsistency of the fines applied.
Thank you, Senator Allen. Minister, you wish to respond to that?
I'm awaiting a technical response, but I'm noting here, so this is regulation 14, paragraph 14. The query is in relation to 14 subparagraphs 1, 2, 3, and 4. Just to ensure the technical team is
and
looking
5.
At the same space. And 5. I'm recognizing, of course, that 1 is in respect of an institution and 1 is in respect of a person, so 1 anticipates initially that there would be a difference between the amount of that fine, but I'm awaiting for the technical team to send me what I understand is that the false self-certification is a document which of its nature can be amended and therefore the pecuniary penalty is lower. It is a document which can be amended as opposed to making filing false returns which are not comprised of documents which may be amended, which are permitted to be amended within the system. So it is a higher fine. One is something which as of its own operation could be changed, so it is less of a fine to make an error or to do it incorrectly. Whereas the fundamental filing, the $1 million fine, is accrued or rather applied because that document cannot be amended by nature.
Okay, thank you.
Thank you very much, Senator Allen. Thank you very much, Minister, for the clarification. I put clause 8. Those in favor? Against? I put the title and enacting clause. Those in favor? Against? The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? I do report the bill as having passed committee stage without amendment. Minister?
Mr. President, I ask for third reading of the bill.
Members would have heard the question from the Minister. Those in favor? Against?
A bill entitled An Act to Amend the Revenue Administration Act read a third time and passed.
Minister?
Yes, Mr. President. Mr. President, it is not intended to do any further business today, but we do recognize that today is the day after we marked a particularly important international day, which sits heavily in the heart of some members and who feel moved today to speak on the matter, Mr. President. So with your leave, I ask that they be permitted so to do.
Thank you, Minister. I can only imagine, I can just wonder, on the motion of the adjournment, I recognize
Mr. President and
Senator
Leader,
Graham.
members, it's not that it is sitting heavily with me. It is a matter of importance as we try to promote the equality of both genders in our society. And I considered the notice and the emphasis being placed on males to be important. It is actually a good thing to be a boy or a man. There are some who have tried to cast doubt on that, and I want for myself to emphasize that it's a good thing. Mr. President, the objective of the day was to raise awareness on men's health and well-being, to recognize and celebrate the contribution of positive male role models to social, cultural, and economic development of the Jamaican society, to forge linkages with multiple stakeholders and male interest groups, to highlight systemic discrimination and inequality faced by men and boys. Mr. President, those are noble objectives, and I wish to commend the government on its effort. Every program that promotes work also facilitates males. Every program that facilitates training or promotes training and education facilitates male. Every program, Mr. President, that promotes health and offer health care and insurance and additional coverage is a benefit to the male of the society. And we we thank the government for the efforts in that regard. Mr. President, I noted the last item to highlight systemic discrimination and inequalities faced by men and boys. And of course, Mr. President, we accept that historically we had a challenge, or where ladies were not properly taken care of. And I acknowledge the importance that we continue to enhance and promote our ladies in our society. But today, it's the males. So we also need to emphasize that the continued promotion of the males, Mr. President, is taken care of. And there are some systemic issues that we need to bear in mind. We need to bear in mind that we have to continue to encourage males to be good fathers, Mr. President, and also not to have children in teenage and the early age when we are not necessarily ready. But as we promote that, Mr. President, we must also bear in mind that there is what I call paternity fraud. And therefore, in a system where there is paternity fraud, if you're going to encourage... Well, I just, whatever. Yes, if it is that you are going to promote, as we should, fatherhood, if the persons or the males have any doubt, the sociologists have spoken about that circumstance, then we should facilitate them checking it out. Because we find that if they are more certain, they tend to be more supportive. We also, Mr. President, should bear in mind the male institutions. We understand the situation of male education. We understand the situation that males are not doing well in terms of university attendance and a number of issues concerning education. And of course, we must bear that in mind, Mr. President, and make special steps. Nothing wrong in doing affirmative things to enhance both gender. And when it comes to affirmative things for male, we should consider their education. Maybe, Mr. President, more male single-sex schools may be an answer. Maybe we ought to consider how it is that we can encourage more males to become teachers. Because whether we like it or not, it is very difficult in the best will in the world for a lady to always be the role model for a boy. It's difficult. It's not impossible because many ladies have had to do it. But it would help if when you go to school, you see a few of them in prominent roles encouraging young men for greater effort, Mr. President. Mr. President, the STEM schools, no doubt, will benefit males greatly, and that's a good thing. But of course, as we look at our own voluntary organizations that are geared to assist boys, whether it is the Scout movement or whether it is the cadet movement and similar movements that are designed to assist boys and to encourage male role modeling, we realize that, of course, with the decline of voluntarism in the society, many of these entities are in fact struggling. And indeed, as government and the ministry responsible for gender sit down to consider how to enhance the genders, these voluntary organizations could well do with some support so that males and role models for males could be enhanced. All in all, Mr. President, it is valuable for us to note that in this society we have had good fathers, good male role models who have done very well. Some of them were highlighted by the ministry in a ceremony recently, Mr. President. And indeed, Mr. President, there are males who take care of children that are not biologically theirs by virtue of their own choice. And therefore, I would like to join in the ministry with the minister, the government, this Senate, to to celebrate our males and to encourage us to continue to do the best we can and to enhance that part of the society that we live and to cease the drift that seems to be happening in our society. If the males, Mr. President, aren't doing well, they tend to flow into antisocial conduct easier than it appears others. And therefore, we try our best to start early so that that type of conduct will be substantially reduced. And I end by saying it's a good thing to be a male.
Thank you, Senator Brum. Senator Morris.
Okay. Thank you, Mr. President, and I rise to give support to the motion on the adjournment and to join with Senator Brum to say that it is good to be a man, but it is even greater to be a good man. Mr. President, yesterday we observed International Men's Day. And, you know, I feel really appreciated that we are here in the Senate recognizing and highlighting the importance of men to our society. I think the latest data from the Statistical Institute of Jamaica is showing just below 50% of our population being males. And, you know, when you hear the conversations out there in the broader society, which I regard as rumbar talk, they say, boy, men are short. But the real issue is that good men are indeed short. And
in short supply.
I am not going to end up on the reference, Mr. President, lest I get in trouble. But, Mr. President, the fact of the matter is that there is some serious challenges confronting our men within the society. And those of us men who have continued to achieve some degree of success need to extend a helping hand to our brothers who have not enjoyed the sort of success that we have enjoyed. And I say so, Mr. President, because as I look around in the Senate, I think there are about 12 of us, 12 males in this august chamber. And we all have been successful individuals in our respective fields. And we are seen in different spheres as role models. And we need to make sure that we extend a helping hand to the younger males within the society so that they understand that it is important for them to play a critical role in the advancement and development of our society. And in doing so, they have to make sure that they pay attention to the care, love, and support of their family. We have to make sure that they understand that it is not good enough for us to just have a child and allow that child to grow up without taking the full male responsibility of taking care and supporting the growth and development of that child. The responsibility cannot and should not be left on the females. And then the whole issue of education, as Senator Braham highlighted, very important and critical to the development of our males. When you look at the education system, and this is a part of the systemic challenges confronting our males, when you look at how the males progress through the education system, as they, at the primary level, they seem to do well. As they reach the secondary level, you see a falling off in their performance, and it hits rock bottom when you reach the tertiary level. I mean, I was standing outside of my office the other day, Senator Braham, and when it reaches about 4 o'clock in the afternoon, you see streams of students passing to go to the different halls of residence. And I was wondering if the University of the West Indies had become a girls' school because of the amount of young women that I saw passing the way there, Mr. President. You know, I tend to get myself in a lot of trouble, you know, but the English language don't require me to say I feel. But the fact of the matter, Mr. President, yes, Senator Webber, very careful. But the fact of the matter is that we need to encourage and motivate our young males to take education seriously, because there is virtue in education. Education has contributed to who I am today. And by the way, Mr. President, last night I collected the award for the Vice Chancellor's Award for Public Service, Excellence in Public Service at the University of the West Indies. And again, it shows that when you put the investment in education, when you put in the work, it will pay off. And every male in this chamber is a living testimony to the virtue and value and importance of education. And we want to make sure that we forge some form of collaboration with other individuals out there in the society so that we can penetrate the high schools and penetrate the primary schools and the vocation training colleges and bring a message of hope to our young men to let them understand that it is important for them to get an education and also to take care of their families. I was very proud that the other day I saw a young man. I live right across from one of the water commission pumping stations. And, you know, he found out that that was where I lived, and he stopped and came over to me and said, "Listen, my boss, in about 98, you came to a vocational training center in St. Thomas, and you spoke to us and you told us to take education seriously." And he said, "Look, here am I today. I am an engineer at the Water Commission." And I was so proud and thrilled to know that, you know, he attributed to that presentation that I made to where he is at now. And so it just shows that once we get out there and talk to our male counterparts, we can help them to be their best selves and be successful in this life. Senator Braham, you spoke about the importance as well for our male counterparts to take care of their well-being and their health. And that is also of critical importance because, you know, we tend to adopt this macho approach to life, and we don't want to go to the doctor to get our regular health checkups and to make sure that, you know, our bodies are in order. And we want to make sure that we encourage our males to do the necessary health checkups, especially the prostate test, to make sure that you get your checkup on a regular basis because it is important. Cancer, prostate cancer is a leading cause of death among men in Jamaica, and we need to make sure that we focus on those issues. Exercise regularly, and make sure that when we exercise, we take the family with us. We must adopt a family approach. Take the wife, take the daughter, take the son along with you in the whole process, you know. So, Mr. President, we really support the International Men's Day and the efforts to make sure that men become more productive and become more successful in the broader society. And we hope that we as men, or what I call influencers in the society, will go out there and give greater support to motivating and inspiring our young males to become role models in the broader Jamaican society. May it please you, Mr. President.
Thank you, Senator Morris. Minister.
Thank you, Mr. President. Mr. President, I would just say on behalf of the women of the Senate, as I'm sure they would permit me as we bring this session to a close, to say that we join our male colleagues in celebrating International Men's Day as we did yesterday, and we too celebrate every good man, every good father, every good mentor, everyone who has encouraged a young boy to value education, to be a good person, and to become a productive citizen of Jamaica. We congratulate Minister Grange on the work that she's doing in expanding the ministry's efforts in this regard. And again, look forward to our continued partnership in society, as Senator Braham spoke of. That is our empowerment of both men and women as we share a more equal world. So, Mr. President, with that, it is not anticipated that we'll do any further business today. Might the Senate be adjourned for a date to be fixed?
Thank you very much, Minister. Just two brief announcements. Apparently lunch is being provided for us in the dining area of the conference center. And I'm to remind members, and particularly the new members of the chamber, that our program continues, orientation and reorientation continues next week, Wednesday, with 2 cohorts, one at 9 and one at 1. So it would be good, if you haven't registered yet, to make every effort to register. My understanding is that some 26 persons participated this week in the morning session, but only 3 in the session that I chaired at 1 o'clock. I don't know if it had anything to do with the chairman, but I'm reliably informed that my session was better than the one at... In fact, one name I didn't even recognize. I still don't know who it is. Pardon? It will be next week, Wednesday at 9 o'clock, correct? 9 is the first quart, and the second quart is 1. You know, I'm not going to make a public announcement as to which session I'm chairing. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? This Honourable Senate now stands adjourned.